Hello everybody. Today I am going to speak about an important topic, and you can call this as a weapon of judiciary in the hands of common public. That is called PIL. I repeat it, it is PIL. It means public interest litigation. Public interest litigation is one of the most powerful aspects in the hands of common public to change and reform the nation. Let me explain you how it works. Public interest litigation is one of the prominent word that has been added into judiciary by Honorable Supreme Court of India. And in addition to this, public interest litigation arises from Article number 226 and Article number 32. Article number 226 and Article number 32 of Constitution of India were called as soul and heart of Indian Constitution. Let me explain you how it is called as soul and heart of Indian Constitution. Every citizen of a country requires a recognition and reserved rights for him to lead a happy and also rightful living in the country. Now let me explain you what Article 226 does and Article 32 does. And Article 226 is for the High Courts of States and Article 32 is for Honorable Supreme Court of India. Now, both these articles have a common point, that is safeguarding the rights, that is fundamental rights of the public of the nation. Now let me explain you what kind of rights of the public can be saved. Now there are so many rights that has been reserved for the public according to Constitution of India, that is citizens of India. All the rights that are mentioned in Article 14 to 19 and 21 can be saved through these articles. And this is called judiciary shield for Indian Constitution. And also it is a judiciary shield for common public. And now let me explain you what kind of petitions can be launched in 32 article and 226 article. Both these articles secures the common public with writ petitions. Let me explain you, even public interest litigation is also considered as one of the writ petition. But it has a vast difference between other writ petitions and public interest litigation. Public interest litigation can be launched by any person in the interest of public. There is no locus standi for public interest litigation. But there are few terms and conditions that has to be taken into note while filing the public interest litigation. The first thing is, the problem that you take for public interest should not have any personal intention or should not have any personal benefit for the individual who is filing the petition in the Honorable Court. The matter concerned is about the complete nation, then you can obviously approach the Honorable Supreme Court of India via Article 32, and in case if it is concerned about one particular state, you can approach the Honorable High Court via Article 226 and file the petition. And again I am telling you, for your remembrance, public interest litigation should not have your personal interest. It should not be for the sake of degrading anybody. It should not be for taking revenge on anybody. It's for the pure safeguarding and also for the pure welfare of the public. And these petitions can be launched in High Court as well as Supreme Court, as I told you. The first stage is evidence and the matter should be collected. In the sense, the subject that you feel that is hazardous, you have to collect the evidences for the same. And the second thing is, you have to prove that this is not on your interest, and you have to file a declaration on the same and draft a petition, file it in the court. Thank you.